Thank you, Bobby. For the past couple of years at the Human Rights Foundation, thanks to a generous grant of the John Templeton Foundation, we've been working on a comparative legal research project called Speaking Freely, where we're focused in studying both the origins and the current abuse of so-called official defamation laws and incitement laws around the world. Quick word about the origins of these type of laws. In Roman law, under Emperor Augustus, he passed a law called the Lex Majestatis. So based on this Lex Majestatis, it was a crime called majestas, which translates to treason, or to treason law, which involved at the time what we see today as incitement and defamation. Quick jump to the 1600s. In the Anglo-Saxon tradition, there was a crime called seditious libel that was used a lot in the American colonies until the Peter Zenger case changed that. But that also was used in England and led to usually both these crimes in ancient times and in the Renaissance led to the death penalty. Now, about the abuse of this type of laws today, this is a good example. Just a couple of months ago, this Shia cleric in Saudi Arabia was executed on grounds of inciting social strife for criticizing public policy by the Saudi monarchy against the Shia minority in that country. Under the exact same charge, incitement to social strife, the main leader of the opposition in Kazakhstan was sent to jail for 15 years just recently, also a couple of years ago in that country. The same Leopoldo Lopez, one of the main opposition leaders in Venezuela, just as in Kazakhstan, Vladimir Kozlov, Leopoldo Lopez, in Venezuela, totally different continent, very similar charge, incitement to commit a crime. He's been serving, he's on his second year now, and he's going to have to serve 14 years in prison in that country. Liu Xiaobo, Nobel Peace Prize, he was supposed to get the prize in 2010 in this town, in this city. He wasn't able to do it because he was in jail. The charge, incitement to subvert the powers of the state, a very common charge that they use against political opponents in China. All he did was to write a memorandum called Charter 08 as an academic calling for democratic reform in China, and similarly bogus sounding charge inciting public opinion in Saudi Arabia to in jail this human rights lawyer who is lawyer for a lot of high profile political prisoners in Saudi Arabia like Raif Badawi. His name is Walid Abu Al-Khair. Coming back to Latin America, injurious calumny was the charge that Emilio Palacio faced a few years ago along with the owners of the journal El Universal for writing on an op-ed piece that the president was a dictator. So the president sued for $40 million and he was sentenced to 2 years in prison. Eventually they got pardoned, but this is used still in Latin America. You'll see tomorrow, hear a little bit more of El Sexto, Danilo Maldonado, charged with insulting the president in the criminal code of Cuba, Desacato, for painting two little porks with the words Fidel and Raúl, and injury or defamation of the injurious kind, of the insulting kind, what in English they call insult laws being used in Cuba. Something very common in Latin America. In Thailand, unfortunately, too many cases of lèse majesté laws. This is the case of a historian charged also under insulting the monarchy charges. And just yesterday over dinner, I want to put this up because Rafael Marquez de Moraes from Angola is here with us. He wasn't here last year at the Oslo Freedom Forum. He had to send a video because he was facing trial on defamation charges for a book that was published outside of Angola where he criticized the government of Angola, and he had to face defamation charges because of that. So the abuse of defamation and incitement laws as a trend is very clear. And we kind of knew this at the beginning of this project. Now we were faced with the dilemma: how do we approach this issue? Do we, in order to advocate for a more protective standard of freedom of speech across the world? And we face the dilemma: should we go to philosophical ideas of the Enlightenment, the French encyclopedia, to influence civil law tradition countries, or Montesquieu, the same thing, or maybe a Rapagitica more on the common law tradition, the Anglo-Saxon tradition, John Milton's seminal speech. But then we realize, if you look at it more closely, these are not advocates that at the time are advocating against the government for a theory that will protect their rights more. They usually, in order to advocate for free speech, they go and find arguments that are more removed from the present reality, political reality, and these arguments at the time, for someone like John Milton, was ancient Greece. So the title itself of his speech is Areopagitica, borrowing from a Greek poet. Something similar can be said of what Montesquieu did. In fact, he was quoting in his famous work on the separation of powers. What he was doing is he was speaking about the Constitution of England and how that led to more political liberty. So that role that is seen positively, popularly, and that comes from a neutral, independent source is played today to a great extent in most countries around the world by international law. So we see that, for example, this seminal work by the Inter-American Commission on Human Rights in 1994, stating that the Desacato laws in the Americas, which are, again, insult laws in the Latin American tradition, came through the Napoleon codes into Latin America and came all the way from Roman law, that they were incompatible with the Inter-American Commission. That led to the eventual repeal of a lot of these laws in Latin America, especially Argentina being one of the most important cases of this type of repealing. So, and to close this argument on the importance of international law today, you had Patrick Stewart on this viral video from a couple of weeks ago, basically stating that that it was the European Convention of Human Rights that gave Britain free speech, something that obviously it's subject to contention, but that's how popular international law is in around the world. So we, in our study, are doing something similar, looking at compatibility of the legal regimes in most countries around the world with the international standard on incitement, the international legal standard on incitement, and the international legal standard on defamation laws, looking at what countries are compliant and what countries are non-compliant. We do this by looking at specific cases. This is a case in Vietnam, a country that is not compliant. Why? Because each of the elements that amount for the international law and incitement, how strict they need to be in order to be compliant with international law, are analyzed there, and that's why Vietnam fails, because in this particular case, as in other cases, it's failed. Another example with Argentina, this is also a seminal case, measured under the same standard. Case in Russia, the same thing. This one is on incitement though. And finally, once you click on that, this is an interactive map that we were able to create thanks to the help of the John Templeton Foundation and the Universidad Francisco Marroquín in Guatemala. And after that, so you click on read more, it tells you for most countries, some countries, not all in the world, but for example, Latin American countries, European countries, African countries, they have two standards to follow. The universal standard called on by the UN and the regional standards, Inter-American, the African, or the European standards that apply to them as well. We measure each country under both standards in this project that again is starting and is only on a beta version, but this is what I came here to present to you today. Thank you.